You know, in the world of lawsuits, there is this incredibly powerful tool, kind of like a secret weapon, that acts as the justice system's ultimate gatekeeper. It's a procedure that can literally stop a case in its tracks long before it ever gets to a trial. It's all about protecting the courts from being misused. Today, we're diving deep into the power to strike out pleadings.
Okay, so let's just get right to it with a question that I think we can all relate to. Imagine someone decides to sue you with a claim that is just completely off the wall, totally baseless. What's to stop them from dragging you through a long, stressful, and incredibly expensive legal fight? Well, the answer is the very thing we're going to break down today.
So before we can talk about completely demolishing a flawed case, we first have to understand its blueprint. And in law, these blueprints are called pleadings. Think of them like the architectural plans for a building. They're the first official documents filed where one side lays out all their claims and the other side presents all their defenses. They are the very foundation of the entire legal dispute.
And these blueprints, they do four absolutely critical things. First, they define exactly what everyone is arguing about, so there are no big surprises down the road. Second, they give the other side a fair heads up about the case they need to defend. Third, they create the official record for the court. And finally, they draw the lines in the sand for what evidence is even allowed. So, the big takeaway here is that because these documents are so fundamental, they have to be drafted with some serious care.
Which, of course, leads us to the huge question. What happens when the architectural plans for a lawsuit are just wrong? You know, when they're totally baseless. Or maybe they're just designed to harass someone. Or they're just an abuse of the whole system.
Well, the courts have a very specific set of tools for this exact problem. And over hundreds of years of law, it's all been boiled down to just four primary reasons for tossing a bad pleading right out of the courthouse. And to make this memorable, we're going to call them the four horsemen of striking a pleading. These are the four powerful justifications a court can use to step in and say, nope, this ends here, before a case gets any further.
Let's meet the first and most common horseman. The argument that a claim has no reasonable cause of action.
Now, this is a purely legal test, okay? The court isn't looking at any evidence at this stage. Instead, the judge asks a really simple but really powerful question. They say, look, let's pretend every single thing you've written down here is 100% true. Even if it is, does the law actually give you a solution for this problem? If the answer is no, then there's no reasonable cause of action, and boom, the case could be struck out.
And what's really fascinating here is how different legal systems around the world look at this same exact question. So in Canada, the bar is set incredibly high. A judge will only strike a case if it's plain and obvious that it has absolutely no chance of succeeding. Then you've got the United States, which uses a plausibility standard. Your claim can't just be possible, you need to show some facts to make it seem plausible. In the UK, they're kind of in the middle, asking if the claim has a real prospect of success. It's a perfect illustration of that global tug of war between being efficient and making sure everyone gets their day in court.
Okay, let's move on to our second horseman. Now, this one isn't about legal logic. It's all about the content and the intent of the pleading itself. Is it scandalous, frivolous, or vexatious?
All right, let's quickly break down those terms. Scandalous means throwing in nasty, irrelevant, or offensive stuff just to embarrass the other person. Frivolous means the case is just plain hopeless. It has no serious point to it. And vexatious? That's when a lawsuit is filed for one reason and one reason only, to harass or annoy someone, not to actually seek justice. In any of these situations, the court can jump in and shut it down. Our third horseman is all about protecting the integrity of the trial itself. A pleading can get struck if it includes something so inflammatory that it creates a real risk of prejudice. You know, like unfairly poisoning a jury's mind right from the get-go. This one's used a bit more rarely, but it's a vital tool for making sure the whole process stays fair.
And that brings us to the fourth and final horseman, abuse of the court's process. This is the big one. The broad, catch-all category that lets a court protect itself from being used for all the wrong reasons.
So what does an abusive process actually look like? Well, it could be someone trying to argue a point that a judge has already made a final decision on. Or it could be someone filing a lawsuit with a hidden agenda, like trying to trash a competitor's reputation. Or it could be as simple as just wasting the court's precious time and resources on a claim that's obviously going nowhere. This gives judges the power to shut down cases that are just making a mockery of the justice system.
Okay, so you hear about these four powerful horsemen, and you're probably thinking, well, if I'm ever up against a weak case, why wouldn't I file a motion to strike every single time? But it's not that simple. It is a really high-stakes gamble. Yeah, this is a total double-edged sword. On one side, the potential reward is massive. You could get the whole case thrown out early, saving a fortune in time and legal bills. But on the other side, the risks are pretty serious. These motions are notoriously hard to win. You might actually end up teaching your opponent how to fix the holes in their case. And the real kicker? If you lose, you could be on the hook for the other side's legal costs for that motion. Ouch.
So how does this whole thing actually play out? It really boils down to 4 key steps. It all kicks off when a lawyer spots that fatal flaw. Then they get to work, drafting and filing a formal motion, laying out all their legal arguments on paper. Next comes the hearing, where lawyers for both sides get up and argue their case in front of a judge. And finally, you have the ruling. The judge makes the call and can do anything from just dismissing the motion to, in the most extreme case, striking the entire claim and ending the lawsuit right then and there.
And this brings us right to the core of the whole issue. Courts do not take this power lightly at all. It's often called a drastic measure, basically a legal death penalty for a person's claim or defense.
Because at the end of the day, this entire procedure is built on a fundamental conflict, a tension between 2 of the most important values in our entire justice system. On one side, you have the need for the courts to be efficient, and on the other, you have the absolute principle of access to justice for everyone.
And that leaves us with the ultimate question, doesn't it? How do we find the right balance? How do we protect our courts from getting completely bogged down with cases that have no merit, while at the exact same time protecting every single person's fundamental right to have their story heard? It's the question that judges and lawyers wrestle with every single day, and it's what makes this gatekeeping power so incredibly important.